ACLU of Texas against the bill. Is that correct?
That's correct.
Proceed.
Thank you, Chair Hefner, members of the committee. HB 1832, by enhancing the criminal penalties related to illegal entry, not only further complicates an already unconstitutional law, but also actually makes it more unconstitutional. That's for a couple of reasons. One, we kind of all know about, we've heard a lot about field preemption in this body as of late. The field preemption here is long-standing precedent from the United States Supreme Court that gives, and I quote, the authority to control immigration, to admit or exclude non-citizens vested solely in the federal government. That's long-standing case law dating back to 1915. I think more so than field preemption, though, that this bill specifically creates conflict preemption. Now, field preemption is when something is so regulated by the federal government as to prohibit its regulation by the state. In this case, we're talking about actual specific conflict preemption, and I think it's in two different ways. One, by adding penalty enhancements. The conflict is actually can be, and the Supreme Court has recognized this since case since 1971, quote, conflict in technique can be as fully disruptive to the system Congress enacted as conflict in overt policy. Our system here of adding these enhanced criminal penalties as opposed to removal, which is the remedy for a lot of these things under federal law, specifically creates a conflict between the technique of enforcing the law, even if we were to say that it had the same end game and the end goals as the federal government's position did. More specifically, there's a direct conflict because these penalty enhancements apply to foreign convictions. Now, foreign convictions become especially important when you're looking at asylum protections, which SB4 had some problems on the asylum protection front. It's one of the things cited in the case that has led to the law being enjoined, is that it does not allow for the affirmative defense of an asylum seeker to abate prosecution under this statute. That becomes even more problematic when you're talking about foreign convictions, because the asylum seeker may be seeking asylum very much because of a foreign conviction. Someone who is unfairly prosecuted for political reasons in another country could find themselves in a situation where their asylum claim is actually based on a conviction where they weren't given adequate due process as they would be in the American legal system. And we're actually enhancing their penalty, making it harder for them to seek the asylum protections that they're entitled to under federal law, and therefore creates even greater constitutional problems than those that already existed. I would say that, there is really just no coherent way in which the federal government can, or the state government can be handing down criminal penalties related to immigration, whether it's these enhancements or in the original text that does not violate the Constitution. And we urge the committee not to move this bill forward, knowing the constitutional concerns that exist with the law that's currently enjoined, that this modifies, and the new constitutional concerns that it creates. Thank you.
Members, are any questions for this witness? Mr. Louderback.
So yes, sir. Mr. Hendrickson, you work for the ACLU, correct?
That's correct.
So if an illegal alien comes into this country again and breaks the law again, and he's already been deported, so it's another federal felony, you're saying that you don't think the state can increase the penalty on that?
I don't think that the state, first of all, I would say it's a federal felony to re-enter the country. Immigration matters are civil.
Yeah, if you've been deported, it is.
Well, immigration matters are civil proceedings. So, and in any
no,
case,
not. They have a criminal penalty.
In any case, the law would be properly enforced by the federal government in that case, and not the state government.
You can go to jail for the federal penalty. Why can't we do that as a state?
For the reasons I laid out about preemption, the court has long found that the federal government has plenary power over immigration. There are a number of reasons for that. One would be that it impacts international relations. We have
impacts international relations? Are you serious?
Absolutely. That is the reason to vest it in the federal government. Not to do nothing about it, but because it impacts our relationship with other countries. The Constitution is very clearly lays out that immigration shall be handled by the federal government, and therefore we have allowed those decisions to be vested at the federal level, and state enforcement of immigration laws has long been preempted by federal law. Most recently, of course, in the U.S. v. Arizona case from 2012, in which they found that multiple provisions of Arizona law related to criminal penalties for employment, applying for employment with false identification of immigration status, which is a federal crime, it can be a federal crime, could only be enforced by the federal government, that a similar state statute was not allowed because it is preempted by federal law, which addresses the issue.
Well, it's real clear after the last 4 years that we need to take care of our state. Thank you.
Representative McLaughlin?
So, kind of going with Sheriff Lauder back there. So when you cross the border, you already broke the law. So now you want us to reward you and not prosecute you for crimes that you're doing because you've already broke the law? That's our problem today in this country. We keep condoning it. I can tell you as a mayor of communities along the border, we caught pedophiles, convicted rapists, murderers, and we released them back into our country. That's not taking care of our citizens, and we should enhance the penalties if they come over here. If we go to their country and commit these crimes, we're not going to be given anything, any consideration.
To be perfectly clear, if there's evidence that they committed those crimes in the United States of America where we have full jurisdiction, we absolutely can enforce the law there. It's the immigration component that is related to, that is so intertwined in this bill, which is what the district court pointed to when they looked at SB 4, that is problematic. The prosecution of crimes under state law for the offenses you just listed, no problem there with the Constitution. That it falls under the state's general police powers, which has long also been held to be within the state's purview. It is when you get into the illegal entry aspect of this that it becomes problematic. And I'll give you one example, going back to the issue of asylum here. The federal law around asylum says whether or not you entered at an illegal port of entry, you have up to 1 year to file a valid asylum claim. That is perfectly allowed under federal law. That is not allowed under the construction that we're talking about here, and not allowed under the law that we're enhancing the penalties for in this bill.
But haven't we in our federal government now got away from the definition of what true asylum is, and we can claim asylum now for just about anything?
No, I wouldn't say that that's true at all. I think, it's important to understand, I think, the historical context of asylum. Asylum is one of the cornerstone foundational parts of international human rights law. It came into being as part of the UN Declaration of Human Rights in 1947, after the Holocaust. Knowing how many countries, including the United States, and Eleanor Roosevelt was our representative there, and knowing that her husband had been involved in this, had denied access to Jewish refugees seeking protection from the Nazis on repeated occasions when given the opportunity and presented with the evidence, we created a sort of fundamental right in that document. Now, of course, UN declarations are not binding on the federal government or the state government, but through the 1967 protocol, we joined into, which furthered the 1951 refugee protocols that were put in place by the UN. We became signatories to that treaty, and we agreed to acknowledge asylum claims. So no, I don't think that asylum claims are broken. I think, we have a backlog. I think that the federal government would be well off to invest more in making sure those cases are heard and adjudicated timely. But as far as claiming that just asylum as a blanket protection is not important, no, I wouldn't go that far.
I respectfully agree to disagree with you on that, because they were being coached on what to say just to claim an asylum clause that we saw in the South Texas. And going back to what Sheriff Louderback said, when our federal government doesn't protect its own citizens, and citizens in our country, in our case in South Texas, become second-class citizens, and illegal immigrants have better rights than our own citizens, is wrong in my opinion. That's my opinion.
Representative Pearson?
Thank you, Chairman. Thank you, Mr. Hendrickson, for your testimony. I do want to focus on the asylum piece,
Sure.
if we could. As I read the bill, this is for certain criminal offenses involving illegal entry. And if you go down to Section 1, Dangerous Aliens Act. So I think you would agree, or maybe you don't, are asylum seekers dangerous aliens?
I wouldn't classify all asylum seekers in any one way.
Well, you're including asylum seekers here in this bill, and I'm not seeing that. So I'm just trying to figure out how you're grouping asylum seekers in with dangerous aliens, which it cites out specifically what crimes would have to be committed. And I'm trying to figure out why you're including asylum seekers with the criminals.
Well, in this case, I think I'm very much focusing, in the interest of being on the bill that's in front of us, on those foreign convictions for similar crimes. Those foreign convictions that we're allowing to be the basis for penalty enhancements could come from the very country where the person is seeking political asylum from. They could have been in a complete and utter kangaroo court that existed solely to charge a political opponent with a crime, which could be in and of itself the basis for an asylum claim. I think we can't assume that the convictions of another country follow the same due process that we would require here for a criminal conviction, that those same protections were afforded, and in the worst cases, we could be sending someone back to a country where they will be improperly imprisoned for a crime they didn't commit because of their political beliefs, and that is very much what our asylum laws are intended to protect.
But again, this bill is not referencing asylum seekers in any way, and I would argue that the people of Texas care less what another country determines is illegal or not. But once they come across the border illegally, again, just looking at the bill, it says punishment for the certain criminal offenses involving illegal entry or illegal presence in this state by a person who is an alien. So are you arguing that we should just turn a blind eye to people who are committing crimes?
I don't see in there where there's a reference to a state crime that is permissible to, again, and I am saying very clearly here that this is about the state enforcing it versus the federal government, and the fact that it's unconstitutional is not about the fact that there is no
okay,
remedy.
Let me give you an example. We have a criminal alien in the state of Texas who, going by the bill, involving drugs or crimes against a person. We should turn a blind eye to that.
I think that you can absolutely prosecute the crimes that you're talking about there, but prosecuting the illegal entry aspect of that is solely within the jurisdiction of the federal government.
I think the people of Texas would disagree with you. I hear your point, but a lot of the times when you're grouping in sections of people who aren't encompassed in legislation like this, your argument gets lost in translation. Again, just reading the bill itself, we are talking about people who illegally come into this country and commit crimes against citizens here. You're saying we should not use that as a part of increasing the penalty.
Well, I'm saying, first of all, that that's not all that the bill does, because it does
But on that
acknowledge
piece, is that what you're saying? I want you to tell me, is that what you're arguing today, is that we should not enhance the penalty of a criminal who's committed a crime, drugs, or violence against a person? We, as a state, should not increase penalties on those people.
I think that it would be within the legislature's right to increase the penalty for the crimes that you're talking about, but relating it back to the illegal entry falls again squarely into, we could debate what the penalties for those crimes should be, but this bill, and especially when you read these enhancements in the context of the statute that they're tied back to, which not all reproduced in the bill, is about illegal entry. This is the crime of illegal entry. That is the crime. These enhancements are related to other aspects related to the defendant's criminal history, potentially, but the crime itself is either illegal entry or illegal reentry. And when you're talking about whether those penalties should be enhanced, we can talk about what the penalties should be for the underlying offenses. But in terms of regulating criminally the illegal entry or illegal reentry, that again, under the U.S. v. Arizona law case and long-standing Supreme Court precedent, falls solely under the purview of the federal government. So it does have to relate back to what we're enhancing, which crime we're enhancing the penalty for, and in this instance, in this bill, the underlying crime is either illegal entry or illegal reentry.
Well, in many cases, past behavior is a prediction of future behavior. And in just a regular court system, if there's a pattern of behavior, that's what increases the penalties. And if you're saying that we should not take in consideration if a federal law was broken or not, I don't understand that.
I'm saying that we shouldn't even be in the business of charging the underlying crime because it's solely in the federal jurisdiction, and that is the way that our Constitution is structured, and that in order to be in line with the constitutional principles, longstanding constitutional principles, giving plenary power over immigration to Congress, penalty enhancements or not, this crime is not within the state's jurisdiction to charge in the first place.
Well, we're going to disagree on that one. Thank you for being here.
Thank you.
Members, any other questions? Representative Lauterbach?
So, Mr. Hendrickson, as we explore this thing, you brought up several interesting ideas, and they're related to 1832. But you even mentioned a kangaroo court for asylee status, and you quoted World War II with not a war with Nazi Germany on asylee status. And we've just went through 4 years of a kangaroo court for sure on asylee status. It's been horribly abused. So in the overall scheme of things here, what Chairman Gertz is bringing to the table is individuals caught re-entering the country with a prior record. So this is definitely within the purview of the state of Texas, getting into this area here under several different clauses. But self-preservation of the state is one thing. When the federal government will not do that and has proven that, and we have to take items in our own hands in order to get this done. So, we're going to have to probably disagree about that. But from your position here, but I think legally it's been proven for some time now that we're able to do these things. Thank you.
All right. If there's no other questions, we appreciate your testimony. Thank you for
Thank
being
you.
here. Chair calls Luis Figueroa.